right. Good afternoon, everyone, and welcome to Who Owns You? The clauses, loopholes, and liabilities no one is explaining. I'm Michelle Erlin, a Vice President and Junior Partners at Colangelo Firm, a PR firm here in New York City, and I am excited to be moderating today's conversation. Thank you all for joining us, whether you're an attorney, creator, manager, founder, executive, or simply trying to understand how AI is changing the way we think about ownership and identity. We're excited to have you all here joining us today. As we are talking today, please feel free to drop your questions into the chat and we'll keep an eye on them throughout the discussion, and we'll do our best to weave in them into the conversation as time allows. Our goal today is for you all to leave with a clearer understanding of how contracts are evolving, where hidden liabilities can exist, and why identity is quickly becoming one of the most valuable assets that we have. I'm very fortunate to be joined by three experts who each bring a different perspective to this conversation. First, we have Andy Blair, founder and managing director of Reverb Data and former chief privacy officer at Universal Music Group. Andy has spent years helping global organizations navigate privacy, data governance, AI compliance, and digital rights. He'll help us think beyond contracts and copyright to the broader questions of consent, data ownership, and how identity itself is governed in the AI era. Next, we have Rebecca Rexide, founder and CEO of Rexide Law. Rebecca previously served as lead counsel of partnerships at Meta and has extensive experience advising musicians, creators, talent managers, and entertainment companies. She works on these issues every day, negotiating agreements and helping clients understand exactly what rights they're granting and what protections they should be asking for. And finally, we're joined by Sam Tall, Director of Platform Operations at Fixated. Sam brings more than 15 years of experience across creator monetization, music rights, trust and safety, copyright administration, and platform operations. His perspective helps connect legal theory with what actually happens inside the platforms creators rely on every day. Thank you all for being here. So to start off our conversation, when you hear the phrase, "Who owns you?" what is the first thing people are getting wrong about ownership in the AI era? Andy, we'll start with you.
I think we talk, especially in the music industry and the content industry, we talk a lot about content and frame things through the lens of IP. But most data isn't IP. You know, the reason that scraping exists and the reason that that a lot of the data collection that's happened by large companies sort of they get away with it is a lot of it has to do with the kinds of data about people they're collecting aren't IP, subject to IP laws. There's no copyright, there's no patent, there's no trademark. There can be, when the data is put together into a song or an image or photography or photograph or something like that. But I think we as creative industries are anchored in IP, and I think because of that, we tend to get pulled a little bit towards that perspective and lose sight on some of the other areas that come into play. And who you are is a lot of different pieces of that. Of course, IP issues come into it, but there's more to it, and I think those tend to get overlooked a little bit because of how anchored we are in IP as an industry.
Rebecca, do you have anything to add there?
Yeah. So I couldn't agree more. The other thing is, people mistakenly confuse technical ownership with actual control and enforcement. Like, the question really isn't things like, do I own my voice? Do I own my likeness? Do I own my content? It's how can you control and enforce that ownership against others? And how do you make sure that it benefits you as an individual and benefits your business?
Thank you. And Sam?
Nothing other than just I agree that it's a matter of true legal ownership versus responsibility of action, which I think is something that is maybe misunderstood and something that we're going to unpack a little bit today.
Great. Andy, we're used to thinking of assets as music catalogs, trademarks, copyrights, or patents. Are we reaching a point where identity itself is becoming an asset class?
I think so, and in some ways, it has been. If you look at the engine that's powered basically all major websites since the early 2000s, it's been advertising. And so what does advertising do? It's based off, retargeting and profiling and all these different things. And so, in a lot of ways, that at least pieces of identity, which may be reflected in your preferences, whether you visited a site, your purchasing tendencies, all those bits of information about you is a form of identity. And that's been an incredibly lucrative asset for quite a while. And I think we're evolving that away from just a number on the other side of a browser who you can serve an ad to, or you can build an algorithm against more of the actual who that person is. So I think we are absolutely moving into that era, and but it in certain ways it's an evolution rather than a whole new idea. Just it's coming from a lot of the advertising industry and that economic engine, and now we're seeing it evolve into more specific identity around what you look like, what you sound like, and those sorts of things.
And at what point would you say does a person's voice, likeness, reputation, style become something that should be actively managed and protected?
You want to take it on the IP side, Rebecca?
Yeah, sure. It's the moment that somebody else wants it. So a lot of people wait until their like list gets used without permission or something else goes wrong. But the reality is then you've already given something away. So we're living in a world where brands are paying people for content where their likeness, their reputation, their audience is part of the deal. We're in a world where platforms have terms of service that include AI likeness, AI training rights. Um, they're telling creators, they're telling individuals, not even celebrities, just regular people too at this point, that your likeness, your voice is worth something. We're almost back in the days where your data about you and almost like the surveillance state we're in now with platforms is starting all over again, but this time it's AI and cloning. And you need to protect it and price it out before somebody else decides for you what that price is, or you're going to be in a world where you won't have control over your own self.
Well, I like how simplified you put it, the moment someone else wants it. So there's also potentially going to be a lot of opportunity for people, if they do protect their likeness, to possibly be able to have opportunities to sell it to others that maybe they never had before.
Yeah, absolutely. That's going to differentiate tomorrow's successful creators from those who are just kind of going with the flow.
Yeah. Sam, if someone in this audience has never thought of their identity as intellectual property, what are they overlooking?
Um, it's easy to overlook like all of it because there's just such a it's so complicated from like a platform management perspective now to do anything other than try and prevent. But one thing that I think we've learned from content protection from copyright for copyright perspective is that you can't cover everything always. And there's the perennial problem of playing whack-a-mole when you own, let's say, some visual media is going to appear somewhere that maybe you don't want it to appear. And try as you might, it's incredibly expensive, difficult, and cumbersome, and sometimes impossible to have that removed from the internet, especially permanently. And the major film studios and record labels pay a lot of money to try and make that happen, but they're just doing damage control. And I think that maybe sets up the fact that we're going to face the same problem, I think, with likeness and identity. And it's just, it's, it, I worry that it maybe falls into the same bucket. That when we talk about to the point of somebody wants it, well, every platform already wants the identity and likeness of everyone on the platform so they can do something commercial with it. Um, but we never achieved copyright protection perfection, and I don't think we're going to achieve that perfection around likeness protection either. Try as we might, um, and certainly we can only hope that it gets affordable enough for the average person to have some kind of like digital identification that validates their presence on the internet. But Is it ever going to get that cheap? Are the resources going to be there necessary? Is everyone going to even be aware that that's a thing? Because we still have to explain to people how copyright works on YouTube when they get a copyright claim or a strike and what that implies. So I think there's just like there, I think there's a world in which fans of creators, for example, are more interested than ever in the behind the scenes, or fans of artists are more interested than ever in the economics of something like making a record or touring. I do hope that the lay person, the fan of content, starts to become interested and fascinated by the complexity and the necessity to how their favorite artists and creators are protecting their identity, and how that might imply that they should do the same for themselves. But that's maybe a big jump to make.
Absolutely. Rebecca, most people assume they're reading contracts carefully. Where are you seeing AI related rights quietly bundled into agreements today?
Yeah. So, funny enough, in most cases, it's just a handful of words in that rights grant. You're allowing the brand to use your content and underlying elements, which is your name, your voice, your likeness, anything you're putting into that final content, for things like sometimes it says things like for any purpose, or it'll even say, including for the purposes of improving company's products. It's very vague, but that's where that kind of language is hidden. And it's something people just read through and go, "Oh, yeah, like, that's fine. Like, I want the company that I'm working with, we have a good relationship. I want them to improve their company products. That's fine." And don't think about what that actually means. And the improvement of company products can include putting your data, your content, putting everything that's in that into their actual training protocols, into their outputs even. So people don't think a lot of creators, especially, aren't nerds like myself who love to read. And their eyes glaze over when they see the rights grant, but that's actually the most important part of the agreement. And that's where all of this generally lives.
And what's the clause that worries you the most right now that people are routinely signing without understanding the long-term implications?
Yeah, it's that for the improvement of company products language. It's across the board. I'm even seeing, I saw the other day a record deal that said that my client would be granting to the label the right to use their music for AI purposes, but it was kind of vague what it meant. And then it said something like, including for generative AI purposes, where we would have to get your approval, but you can't withhold that approval unreasonably. And I was like, okay, well, in this world, what is unreasonable withholding of approval? Like, what does that even mean anymore? I don't know. What if my artist just doesn't want you to use their voice for, a sync product that you don't want them to have to work on, or that you don't want to pay them for? Like, what does that even mean at this point? And so we're seeing that across the board in creator deals. We're seeing that in music deals. And I'm sure that I don't do a lot of film and TV, but I'm sure that we're seeing that in those two now.
And if you could force every creator, artist, or executive to review one section of every agreement, would it be that?
Rights grant all day, every day. People don't think about it this way, but they should. If you're a creator, you're an artist, you are a creative person, you are the CEO of a company that is rooted primarily in intellectual property, and your payment terms, the approval rights, everything else in that agreement revolves primarily around the intellectual property that you are granting and what you are allowing somebody else to do with that intellectual property. And like I said, a lot of creatives, their eyes glaze over when they see the rights grant because it's got a lot of legalese, but that's the heart of the agreement. So needing to read that, and importantly, understanding what it says instead of just going, "Oh, this is a lot of words and it's a lot of very big words. I don't know what this means." Like, that is paramount in understanding what you're agreeing to and what you're giving away.
Andy, this question's for you. From a privacy perspective, are companies asking for consent in ways that are technically legal but not meaningfully understandable?
Yeah, I think so. And that's long been a practice, before we got to AI, very broad, I consent to this, and bundling consents in signups to services and all sorts of things like that. I think the way that we're seeing it differently here with respect to identity and AI is that most modern privacy laws define biometric data as what we call a special category of data. So
Mhm.
it's something that has heightened protections. And so in Europe, it's its own class. Special categories of data or sensitive data. In the US, it's often treated that way. And there are certain states that have specific, very sensitive biometric protections. And what those typically say is that you need consent to use somebody's biometric data. Um, and it can get into the why and what you're using it for. There's some limitations around using it for identification purposes or authorization purposes or something like that. But the idea is that, hey, this is sensitive data and people should have more control. They shouldn't be forced into saying that others can use it. And um, the reaction to that typically is, well, how can we put this consent under the radar as much as possible so as many people as possible say yes to it and as few people as possible say no. But there's some really interesting things around that. And is it legal to do that? In many cases, the laws are getting to a point where it's very difficult to get proper consent without it being separate, like separating out using your biometric information. And so a lot of social media platforms in particular, with like friends you may know and all those different sorts of features, those are all facial recognition. That's basically what they're all doing, which is biometric. And there have been lawsuits in Illinois and in Texas and a bunch of other places challenging them, saying, hey, you're doing this incorrectly. So yes, absolutely. Privacy law is inherently about the rights of the person, which is different than IP. IP is kind of a property law, right? It's trying to incentivize new creation of content and moving something forward in more of an economic sense. Privacy laws are all about dignity and your control over things. It's more consumer protection law. It's why it's enforced by the Federal Trade Commission in the US, right? Because it's more consumer protection law than anything else. So the game of putting in consents and agreement to do things in as unobtrusive way as possible is absolutely the game. And Rebecca talked about it in the form of like a label deal, right? They want to basically get your biometric consent without saying, we need to get your biometric consent. So I think that's absolutely widespread. And it has been for a while, again, in different contexts, but that baton's been picked up and is absolutely being used in the same way.
I mean, you gave a great example. I see it all over my social media pages, everyone putting in their faces to see what they're going to look like in 50 years. And essentially, those companies are taking, data from their face. So can someone truly consent to the use of their identity that doesn't technically exist yet?
So privacy laws are really about the use of the data. So they would not look ahead into something that doesn't exist yet. But if you're using it for training and other things, the stuff that's there today, matters. And then the other aspect of it is privacy laws are purpose specific. So you're using the data for what? And so you don't just have a consent to say, I approve you using my biometric data. It's I consent to using my biometric data for the purpose of X, Y, and Z. And so it's really supposed to be set out. So it's purpose limited. In practice, that's why language like improve our products is used, because they're trying to get as broad as possible. Now the validity of that is a separate question. Can you be that vague, and is the consent specific? And I think in the look ahead way that, if you were talking to a European regulator, they would certainly say you can't blanket consent to some future vague uses of things that you're not defining. And I think Illinois and potentially Texas would agree with their own biometric laws. But one of the challenges is that is so very inconsistent, even within the US and then across, countries around the world. The GDPR, sort of European style of privacy law, is gaining prominence. It's probably the most common now. But that doesn't mean, to Sam's earlier point, that the enforcement is there. And, that's an absolutely critical part of it. And most of these laws, individuals can't, they themselves go force a company to act. They have to go through a regulator. And if, you're seeing things like regulatory capture and And I don't know if any of them are on the call, but the UK's regulator in particular has been incredibly lax in going after people for things, and they have a bit of a reputation for that. So you have the rules, but then you have to enforce the rules.
Yeah,
If I may, from
absolutely.
an intellectual
Yes,
property
please.
perspective, like that, the privacy law is one thing, and then the way that these contracts exist for IP rights transfers, this is part of the problem we deal with now is when cable TV and the internet and all of these like earlier iterations of progress and technology started to come on the scene, record label agreements and creator agreements didn't exist yet, but talent agreements all granted rights for all media now known or hereafter devised. So that covers uses that we don't know exist today. That covered when we switched over in the music industry from physical sales to digital streaming. That was covered already automatically by that kind of language. And that language continues to exist today and is being used as a way for companies to stake claims on AI uses of intellectual property that they've been granted in the past. Because a lot of these agreements have been in existence for the last 10 years. Some, record deals can last 15, 20 years sometimes over the course of multiple album cycles, sometimes longer. And so companies will kind of rest on their laurels a little bit and be like, look, like we already have these rights. You don't get to decide now that we don't get them, using this all media now known or hereafter devised kind of language.
Wow. Sam, when an AI generated voice clone, image, or piece of content appears online, who actually owns the responsibility for policing it? The platform, the creator, the rights holder, or all three?
All three share some part of that responsibility. I think the platforms themselves are best positioned to take the most significant actions. Unfortunately, without laws requiring them to do that, there's no, uh, let's say, negative incentive to do that. And there are only positive incentives insofar as it helps position them as the place that's safe for creators or in some kind of marketing position. So, you know, I think notoriously, platforms like Instagram or TikTok have tried to do as little as they can with respect to rights protection for the sake of like it's necessary to enable DMCA takedown requests or some other means of protection as a result of precedent that they've been put under. Whereas YouTube, to their credit, they started that way and then realized this is actually a force for bringing creators onto our platform and creating economic power for us as a company. So we're going to build the tools that allow them to, allow them or their distributors to self-police and participate in the process. And we're seeing this reflected, I think, in the way that platforms are starting to develop tools around likeness protection or deepfakes or other sort of things that fall into that category. And the same party lines are largely being held as far as I'm seeing, which is to say it's not nearly enough from anyone. And there's nothing that covers everything, at least from the platform side. So creators and their representatives are really in a position of having to defend themselves and in a practical sense, that's like an inordinately huge issue to solve for any one person. So something collective, I think, makes the most sense as a force. I don't know, maybe Andy and Rebecca have some thoughts on this. I don't know if we're going to see regulation that actually speaks to this problem from a functional level, because again, enforcement is the problem, and at least pushing the platforms into a position of having to comply with the thing that like a creator might ask them to do and have that be just the way that it goes would be great. The DMCA is old and rickety, but it at least has that requirement, and there are consequences to not following that requirement. And I would like to see something like that happen. But again, that just shifts the burden to creators and their representatives to actually take actions wherever that exists, and for tools to emerge that allow that to happen at scale, which would make my job a lot busier, but also a lot easier in certain regards.
Yet it seems like, right now creators just have to be aware and looking out for these things and protecting themselves. Because to your point, the platforms may not be up to where they need to be to protect creators that are participating on their platform. So it's really in the hands of the creator right now to make sure that no one else is monetizing off of their likeness.
And there's no shot that that's gonna happen, to be clear. Like, creators at large are not one unified body with one singular experience, and so even, I've had the pleasure of working with some really, really smart, fairly small in terms of audience size creators that, like, totally get it. They're very, very involved
Mhm.
in their business, they really care about protecting their rights, obviously, they're interested in making as much money as possible because this is their livelihood, and then there are very, very big creators who make lots of money and don't seem to care at all.
Mhm.
Some of them care a lot because they only got to that level of success by caring, and then there are some that frankly can't be bothered to even comply with normal pedestrian laws. So they just go out into the world doing crazy stunts and make a lot of money doing it and breaking international laws whenever they're visiting a foreign country. And they would be damned if they were ever to kind of like sit down and try and understand how this works or why it's important. And in some regards, there's even a prevailing opinion that like everyone should just use my stuff always because it's good marketing for me, or I should willfully give my identity into a platform. Maybe they'll cut me a check. That's the one time you get paid for that use, but everyone can use it in perpetuity after that. But hey, my face is everywhere. And so now I'm more famous than ever, and I can parlay that into some other kind of money. And what legacy that creates is irrelevant to them because it's sort of a very sort of egocentric, I won't say egotistical
Mhm.
or selfish, but very sort of egocentric. It's just about me and my perspective on the world kind of approach to how they handle this. And everyone else can do it their own way as far as they're concerned. And that's frankly a
Well,
valid read. It's just not like the most
yeah.
effective one.
It sounds like it's their strategy to keep their fame, but I think everyone may be, have a different perspective if they start to see who's actually making bigger money than they are off of their likeness. So only time will tell that, what happens there. But, this is again for you, Sam, and of course the other panelists, please chime in. But what's the biggest misconception people have about how content enforcement actually works behind the scenes?
I think one of the biggest misconceptions, especially about the way that it's been done with regard to YouTube for the last 10 years, is that um, if you use someone else's content, you're just going to be sued into oblivion. I think we saw a lot of maybe aggressive legal behavior at the origins of digital media that creates a legacy of like hyper intense enforcement and copyright so expensive to pay the fine for and all this kind of stuff. And it's usually not that. It's usually just like, "Hey, please just, like, stay within the lines," or, like, "Just let us make the $3 that you would otherwise make from this video, and you don't really care about $3 anyways, so what's the big deal?" But then it becomes a big blowout with people that don't understand, what the rules are, and they start to drag some creator or company on Twitter or something like that. And I would
Mhm.
say that maybe the second most common misconception is that it's, like, easy and fully automatic. Um, so that like on the one hand, there are people that just don't think it matters or that it's hyper enforced. On the other hand, is people that think like, oh yeah, I can enforce my rights, like no problem. As soon as I am working with the right company, like it just takes care of itself. Whereas like
Mhm.
there's multiple people on my team working all the time to keep uh accurate claims on YouTube and other platforms and making sure that things aren't misused and making sure that we're maximizing the revenue potential for people that actually own that IP, the creators that work with us, and it's a full-time job for several people, and even still, it's a piling problem. You know what I mean? Like,
Yeah.
it's almost like an infinite problem that we will never reach the bottom of the well of, and that keeps us in good business, but it also creates this, the sense with somebody who thinks their rights might be being handled correctly by someone that they're working with. And, I think we care a lot about doing it right. We also don't work with everyone. Like, we could not, and we don't really want to commercially. And so if you are working with a platform that tries to work with everyone, like a self-service music aggregator, for example, if you're an artist and you think your rights are being protected, top to bottom, they're mostly going to be doing the automatic minimum that's available without really going to the ends of making sure that anything that's niche or at all involved in a manual review kind of way is actually being handled because it's not commercially viable for that provider to do. So I would just caution creators to understand who you're working with, what their capabilities are, understand where the limits of those capabilities are not actually your distributor or service provider's fault. Um, I can't do everything that I would like to do because some things just simply don't exist yet. And when they do, we'll start to offer them. They might be expensive and not for everybody. And so that's kind of the deals that we make at this point in time.
And there has to be, the thing here too is that we're dealing with AI, which potentially could be pulling
Mm,
things from creators without anyone really knowing, right? It could pull something so small as a sliver of what they've created on a YouTube video, and it's hard to detect. I think that's, what's alarming is it's not necessarily, yeah, sure, it's someone, if you take a whole song, okay, someone's taking that song and putting it over here and they stole my song. But if they're taking components from a whole bunch of creators to create something, I think that's a bigger problem that we're dealing with. And I don't know if any of the other panelists have any thoughts on that.
I would love to know what a lawyer's perspective on this is, actually, because we run into a problem constantly with heavily modified copies. And I'm not talking about newly generated media, but literally somebody takes a segment of a video and green screens the background or like warps the colors, and technology gets better, but it's not perfect. And like we're powerless to do anything to find it most of the time, let alone take action.
Yeah, finding it's tough. If it's truly the content that's being modified and it's actually a modified copy. The thing is there's this blurry line that exists now, right, in copyright, where at what point is it that you're taking the content itself and changing it and modifying it, but it's still that underlying content? And at what point is it something else that we haven't really contemplated in copyright law? Because copyright law will cover the content itself, the creative expression, the original creative expression that's fixed, but it doesn't cover me talking as a human out in the world, unfixed, not a creative expression, or my face. It will cover the video of my face, but not me. So there's like these weird gray areas now that we didn't really contemplate in the law because it wasn't something that came up before, and it's moving so much faster than the law can really catch up to. When it comes to the actual content that's being changed and modified with AI, copyright does cover that, and it becomes the standard of substantial similarity that copyright law applies. The same as if I were to take a video and edit it in iMovie, Final Cut, really heavily myself as an individual. The law contemplates what an individual human being can do more than it contemplates what an AI can do at this stage, because it was devised at a time when AI wasn't really the dominant form of making new things. So if it's really a copy that's heavily modified, warped colors, all of that, like you said, Sam, copyright law might be a good valid path to go down. It's hard to find it, like you said, and to actually enforce it. But from a just like the black letter law legal perspective, if there's a substantial similarity, you have the ability to look at it like you have a real case here. And the DMCA would apply to that too, because it's copyright.
So what you're saying is if I want to become a Grammy award-winning singer, I better go quick because I can't sing, so I have limited time to get this done.
I mean, if you're gonna make a new voice, like if you're gonna do Ursula from Little Mermaid and like have a little seashell around your neck, like I don't know what copyright can really do about that at this point. Right of publicity might cover it. Trademark is a weird path that a lot of celebrities are starting to go down that I don't know if I advise it or not. I change my mind on it every day. But the reality is IP law wasn't created with the current world in mind, and we're all just rushing and racing to try to keep up with it.
So that's a good segment, actually. Let's talk about some of the gray areas, as you started to talk about already, Rebecca. But let's say an AI model studies my public content, learns my style, and produces something that feels unmistakably like me, but doesn't use my actual image, voice, or words. Has anything actually been stolen?
Well, under the current copyright regime, probably not. it doesn't like, as I said, it doesn't really cover like style, voice, aesthetic. It's genuinely like original creative expression fixed in a medium. That is what copyright is. And if an AI is like kind of replicating the feel of you without using those like protected original creative work fixed in a medium, or if you're trying to go the trademark route, a particular calling card that you're using in commercial in the course of commerce, um, the most current legal frameworks don't really have too much to say about it. The closest thing you've got is the right of publicity, and that's a state by state thing. And most of it hasn't really also been devised with the current world we're living in mind. Some states like California and Tennessee have the beginnings of AI informed right of publicity frameworks like the Elvis Act in Tennessee. But the right of publicity also really wasn't built for this. It was built with like endorsements by athletes in mind. So we can use it and try to shoehorn it into today's world, but it's hard to say something was stolen from a legal perspective because we don't know what the intellectual property exactly that we're dealing with is. We just know that there's something that isn't really being covered right now, and the law needs to run to catch up to that.
And there's
So
some
essentially, oh, go ahead, Andy. Go ahead.
and there's some distinction too between the output and the input. And there's still some litigation obviously working its way through the courts, but there's potentially an angle here of, well, if your content was scraped and used to train, and how was that done? You know, there's still a lot of gray area around that. But I think, you know, ultimately that's, if this is going to get fixed and covered in the IP respect, that's probably the area where it would be, because you've got, as Rebecca said, you have a thing, you have the fixed you know, creative expression that's getting ingested. It's a lot easier to protect that than to try and figure out what contours to cover on the output. And you know, and it's legislatively and public policy wide, it's hard. I mean, looking across history, in how many instances have, you know, lawmakers put out legal frameworks that really make sense, and you could look at it and say, oh wow, that really works. I mean, it's, you know, it's sometimes there are winners and losers, and sometimes just everybody is frustrated. And you know, so it's sort of, I think the simpler the better on these things. And if you can cover, you know, the output on this, I just look at it and I say, I have zero confidence that our legislators will find an out there. You know, maybe there ends up being a likeness or, you know, something like that, where, you know, if you look at it and you're like, yeah, that's Taylor Swift, even if it's not her face or her voice, it's clearly like, you know, maybe that becomes protectable in some way. But again, DMCA, I think there's a lot of ways today you could say it misses the mark a little bit, you know, and in public policy, you're sort of, you're picking, you know, where on the spectrum you want to land. And, you know, I think if we made platforms a lot more responsible, they would probably be much more restrictive on, you know, what could go up and how, and the experience would be different. And, you know, I feel like they could do better on some of those sorts of things. I don't know that we're at where we're now is ideal, but, you know, going the full opposite, you know, creates other problems. So it's a really interesting space of not just what the law is, but where in the process should you apply the law to get the outcomes that protect creators and protect, you know, who you are and your work, at the same time, you know, are workable and are enforceable.
I
Well,
think
I think it's also. Oh, go
sorry,
ahead, Sam.
if
Go.
Lionel
No,
Richie
no.
wins his petition for trademark, I may well start advising as many creators as I work with to start having catchphrases.
Yeah.
Like that would become like a weird precedent pathway to protecting something identifiable.
Yeah.
That, I mean, obviously it doesn't work for music because you have to have hit songs that become identifiably yours. But for creators and from an endorsement perspective, I mean, if you have a catchphrase that is recognizably, you know, your identity, okay, I'm going to start coaching everyone on like crafting a creative catchphrase that is unique to them so that we can use that as a shoehorn, to Rebecca's point, to take advantage of the rules that exist and create precedent.
Well, I
I
think
think
we could.
Madonna did it already, you know.
I think we could start right here in New York City with the guy who made up the new Knicks anthem. Someone needs to go find him because I see it being used all over the world now in every city. So
I'll go all the way back
I
on
think
YouTube
that's a
into the
perfect
archive.
example.
Anton Dodson, find your kids, find your wife. We're gonna put that into some likeness protection.
Yeah. And it's interesting too, because a lot of those things tend to bleed through on generative AI. where, there's like the concept of memorization or very close things. And if there's certain words that on the training data are always associated with other words, that's gonna come out. And if it is a protectable catchphrase, then I think, to Sam's point, I mean, none of this is a magic wand by any stretch, but you start to see some things, you go like, oh, that was definitely from my content, or because that catchphrase is mine. It's an interesting concept. Yeah.
I think it has to also be a somewhat exciting time for you guys as attorneys, because essentially you're applying 20th century legal frameworks to a fundamentally brand new problem, and you're going to see the law, catching up and evolving with all these different public policy lawsuits and lobbyists coming forward. So all right, let's talk a little bit about what happens next. Do you think regulation will lead innovation here, or is the industry going to establish standards before the government can even catch up? I actually think we might have answered that a little bit, but if anyone has any additional thoughts here.
I'll jump in. I think one of the really interesting going forward legal precedents will be around, in the US, it's called Section 230, and liability of platforms for things that happen on their platforms. And so since this Section 230 of the Communications Decency Act essentially made it so platforms are not considered to be the speaker for user-generated content on their platform. And it provided protections against defamation and all those kinds of things. If somebody posts something on a forum, the operator of that forum is not held to be the speaker and can't be sued the way that you could, like a newspaper or something like that. It's interesting because in Germany, in the last couple of weeks, I think it was, a couple of companies sued Google because their AI summary created some things, hallucinated, and basically tied these companies to bad behavior or scandals that they had nothing to do with. And they said, hey, your AI is saying things about us. And the German court said, yeah, that's Google speaking. And, to me, from my view of the world, that's exactly how it should end, right? This isn't user generated content. It's not something from someone else. It's an AI created by that company saying things in commerce about someone else. And if those things are not true and are defamatory and are, basically making up bad things that company did, of course it's going to damage them. And of course Google should be liable for that. That to me seems like a no-brainer. But the way that the Section 230s worked over the last few decades doesn't make that a necessarily an open shut case. And, in my view, it should even go farther. In my view, we should be a lot stricter on algorithms too, because if companies are developing the algorithms that are choosing what content to put in front of you, there should be some product liability behind that. Even if they aren't the speaker, they chose which speech to put in front of you. And I think there's some accountability there. So that, to me, because everything is so algorithmic, is there responsibility and accountability there? And so if there is, I think that, that makes a big difference. And I think that bleeds over into a lot of the identity in other spaces as well, because, again, a lot of the reason generative AI and other models and data scraping and everything else has been so aggressive is because there's been no pushback. And there's been very, very weak tools to push back. And so if we start reestablishing that, hey, if you're out there doing these massive things and there are harms that come out of it, there is some accountability for that, and there should be. And so I think that's a potentially pivotal moment. And if that becomes the standard, saying, hey, if your AI hallucinates and it does something that causes damage, then you are responsible for that. And I think that concept very well could go over into AI as well. So, today everybody likes to put all the liability on their customers, on the creators and that kind of stuff. But that particular decision, to me, especially if it gets enshrined in law, product liability type law, could be really powerful tool, because then it kind of curtails the ability of generative AI to say, hey, some user in, Poughkeepsie put in this prompt, it's their violation, not ours. And I think that's a really big, important, fundamental legal thing that if we get right, will make everything a lot easier to protect. And if we get it wrong, we kind of stay in this purgatory where, yeah, there's a DMCA, but ultimately very weak tools against the platforms themselves from creators.
So, Andy, what developments are you watching most closely from a regulatory standpoint over the next 12 months?
Uh, that was it. Yeah, yeah,
That's
that
it?
was it. That was that one. That one and biometric laws in general. Again, there's some very aggressive moves by Texas in particular. Around and Illinois has a private right of action, which legally means usually under US and European law, if there's a violation, you have to be harmed personally, and then in some cases you can sue. In some cases, it has to go through like an attorney general or a regulator, or whatever. There's certain laws that have these combination of private rights of action, which means you yourself can sue, and statutory damages, which means you don't have to prove how much you were hurt. The violation is deemed worth X amount of dollars, and so what that creates is a bit of an incentive to class action ambulance chaser sort of stuff, but at the same time, it has really been an effective um, curtail on explosive growth of biometrics. And because now we're seeing things like license plate readers and cameras and surveillance in public and all this content being generated and video being generated in areas and spaces and in situations where people have no way to control them. And so again, that's another sort of side channel attack if you're in the cybersecurity world there, where if you've got like a public courtyard video camera, somebody's caught recording your likeness, and you may not have any sort of ability to negotiate the use of that, so they may be just porting that off to do biometric training and facial recognition training with like video coming out of public spaces, and there's no angle for you without something like these biometric privacy laws. And so that's the other part is where do those go? Currently in the US, very weak at the federal level, the national level. A couple of states are pretty strong. Which direction does that go? Do more people follow Illinois and Texas, or do more kind of pull back? And how does that interact with sort of the expansion of the surveillance state and like the Ring camera find your dog feature that had the backlash in the Super Bowl commercial, just because of just the explosion of cameras and recording happening everywhere.
Yeah, I always find myself photobombing. I'm
Yeah.
really hard
My
to
tinfoil
avoid it.
hat's right over here. I'm gonna put it on. Just kidding. But there's so much, there's so much happening. It's so hard to keep up. And so, for people here, it's like if you feel overwhelmed by it, so are all of us, that work in this stuff professionally. It's a wild world at the moment.
Yeah. And Rebecca, how do you think creator and talent agreements will look different 2 years from now?
Yeah. So for one, AI related rights are going to be something that's going to be specifically negotiated in every single deal, the same way that digital rights have become standard in music deals and in talent deals. When we move from that physical market to the digital downloads and streaming, I think we're going to see more specific provisions that call out synthetic media rights and digital replica rights. Ideally, those are scoped separately and compensated separately. And I also think that we're going to see a very big stratification between creators and artists who treat their business seriously as the IP business that it is and price accordingly and protect their data accordingly, and those who don't really think about what this could mean for them in the future and kind of treat it like it's not important and allow just anybody to use their likeness, to use their content to make new media that doesn't involve them and effectively cut them out of the equation. Because those people are going to find that their image, their ability to make new content, their skills, what makes them, valuable in the eyes of the consumer is going to get diluted by a lot of probably pretty subpar replicas of them. And that's a complete career killer for a lot of people.
And Sam, in terms of operational changes, do you think platforms will be forced to implement as these issues become more mainstream, more talked about? Um,
I imagine that they will have to, and something that I hadn't considered until Andy pointed it out is the editorializing of speech. Um, Platforms like YouTube are really clear when it comes to copyright that they don't intervene in copyright disputes because that would constitute editorializing or decision making about copyright in a way that violates safe harbor. There are things that they can't do in terms of deciding what people can and can't say, with the exception of things that are maybe like um, indecent at large. They can't have pornography on their website. that kind of a thing. And there's maybe even just commercial reasons why they wouldn't want certain things to happen, and so they write their own policies in those cases. But they do have things like YouTube has a feature called Dream Screen, where if you make a YouTube short, you can have an AI generated background. What does that background contain? What are the limits of what you can prompt it to put in the background? And are you as a user responsible for that background if you didn't actually design it? Is YouTube responsible for what it displays? And does that constitute a rights infringement, copyright infringement, or is that a speech issue? Like, where does that fall into the bucket? And I think the technology is moving faster than policy, and that's how it almost always goes. And then we're all collectively going to have to decide how we feel about that before even a law can get written, because the laws are going to be responsive to the behavior of the culture of the people that it's intending to govern, usually. And so I think the platforms are going to eventually have to develop systems that enable people to take certain protective actions. I think they may also start to roll back features that are either A, legally problematic and they become quagmires of their own making, or B, are simply just underused and people have a negative response to their inclusion in the platform. I don't think we've gotten there yet. I think there's probably a vocal minority that are very opposed and a silent majority that just don't care. I don't think there's anybody that's like ardently in favor of using like Dream Screen or TikTok's version of that or Meta's version of that to create content on their own profile, because your profile is about you. It's about what you want to show to the world. And if you want to show people AI content, that's fine, but that's not what makes creators famous. That's not what makes artists famous. That's not what I want to share with my in laws, right? Like, that's not why I post photos of the family. Um, and if someone were, I'm personally protective of posting photos of my 1.5-year-old daughter because I don't want that to become training information until she has her own right of consent. You know what I mean? And if someone were to take that away from me, I would be personally offended and I would want to see some kind of action taken as a response to that. And that action personally is not available to me. Maybe enterprise level, we could do that, but I'm not a famous content creator. Right. So to answer the question succinctly, yes, the platforms will have to do something at some point. I think it'll have to actually end up happening by obligation and not by their own inclination to bear responsibility or keep community or something to that effect, because frankly, they've had commercial success doing the opposite.
Mm. All right. Well, we have about 5 minutes left. So I would love to hear from each of you. If everyone on this Zoom today only remembers one thing from today's discussion, what's the one action they should take in the next 30 days to better protect their identity, rights, or business?
Well, I would
Don't all speak at once.
I would caution people to review what rights you're giving away and all of the agreements that you have. And that's not just ones that you're given and told, hey, I need you to sign this and sound it back. That's terms of service of platforms that you use. And to the extent that there are opt outs available to you, make sure that you're exercising them if they're made available, if that's something you want. Just make sure. I'm not here to tell anybody, oh my God, don't give away these rights if that's something you don't care about or you're okay with. But I am a huge advocate of being informed and making informed decisions. And without actually investigating and ensuring that you know what you're giving away, you're not making informed decisions and other people are making those choices for you.
And I
Before
think,
we actually move on from that
sorry.
point, I just want to follow up with an additional question to what you've said. So, Rebecca, 5 years from now, what do you think people will be shocked they were giving away for free in 2026?
I think people are going to look back and go, wow, I shouldn't have uploaded all of this, all of these photos and videos. This is for like lay people. This isn't for creators and talent. I think, myself and my friends who are uploading TikToks of like, Mom, what were you like 10 years ago? And upload a picture from high school, right? And then like a picture next to it of you now. Um, I think we're all going to look back and be a little horrified at how much we were giving away to allow AI to train on our own photos, our own videos, our own data without getting anything in return, really. It's the same as like I kick myself now from when I was in high school. I didn't know any better. all of the data I must have given away on my own behaviors and decision making patterns to Meta when I was using Instagram and Facebook as a high school student. Like, I'm sure they know so much more about me than I would love them to know about me. And I think we're just digging deeper into that hole of like being able to recreate a person's behavior, their decision making, a profile on them, and also their face, their voice, the kind of content that they make, the kind of music that they like that they can make on they can play on a guitar. Like it's just continuing to create this ever clearer profile of you as a human being digitally. I think we're all going to go back and go, wow, I let that happen.
I'm fortunate I missed the my college years missed the social media era, so no one knows about that. Andy, going back to that first question, what is the one action they should take in the next 30 days, in your opinion?
I don't know if it's a single action, but one of the important things about all of this is individual creators, including very large artists, have very little capacity to move the needle on the system. And, all of the rights grants and things that Rebecca has been pointing out, most of these are boilerplate terms. In many cases, you have zero ability to negotiate. So seeing them and realizing they're there is important, but your ability as an individual to negotiate is quite small. That said, all of the platforms we're talking about rely on you and the thousands and hundreds of thousands of your, peers for their existence. And so, find community and look for and participate in efforts to try and get some consolidated, negotiating power. And to the extent that there, organizations and that are, in the music industry, a lot of management and others, there are groups that are emerging that are working on a lot of these sorts of things. But as a collective, you have a lot of power. As individuals, not a lot. So take that part seriously. Find your community, find your outlets that you can make whatever your views of the world are known, because you can change some of these things if enough creators band together and say, hey, here's the standards that we expect platforms to operate on. And there's enough of you to move the needle, and you say, okay, well, TikTok's agreed to those, so we're all going to go to TikTok and lower what we're doing on Insta or lower what we're doing on Threads or whatever. You will see responses, and so you will see the world get better. So don't underestimate your collective power, but understand that it's not you. Everybody individually struggles to move the needle on these things. They're big, huge issues.
Thank you. And Sam?
Kind of in service of understanding what you think and what actions you want to take and how you vote with your feet or your dollar. Something recreational for people. Go read William Gibson's Neuromancer. Go watch The Matrix. Go watch Pantheon on Netflix. Go play Cyberpunk 2077 and get cognizant of what sort of sci-fi tells us the future could be like, because we're actually already doing a lot of that already. And the last 50, 60 years of entertainment tells us that some part of sci-fi tends to bear out because someone thinks it's cool enough that they want to go and build that. And so that's exactly what's happening now. We're building a lot of that stuff. And so watch or read or play all the media that is related to the future, and that especially where it involves artificial intelligence or brain scanning and face scanning and replication and stuff like that, to just see how it makes you feel and just see where you like start to sense your own opinion on the matter, just so that you, when it does come, if it does come down the pike to all of us at the pedestrian level, you might already know how you want to react to that instead of being utterly confused and befuddled.
Awesome. Thank you. And thank you again to Andy, Rebecca, and Sam for sharing your expertise and insights today. If anyone has any questions for the panelists or anyone in the Royal community that we're building here, please send them our way and we'd be happy to work on getting those answered for you. Thank you to all of you who joined us today to view this webinar on behalf of Royal. We really appreciate you being here, and we hope you will enjoy us for a future Who Owns You discussion. Have a good day. Thank you.